Since something is going on, I was just presenting few slides, not because they are essential, but possibly because they could allow to follow more closely some of the points I am making, since I am suggesting, according to the title of my talk, something which has to do with possibly a debate, especially in the afternoon, about the role of the tribunal, because many things have been said. And so I would prefer just to put some concepts more clearly. While waiting for everything is ready, just to present myself, I am, as I've been said, the Secretary General of Permanent People's Tribunal. I am not a lawyer, not a juridical expert. I am a medical doctor leading research group in the area. Possibly I'm also in this sense a representative of peoples, not simply those who have a competence. Sorry for the technical delays. I was saying that the points I will make could possibly be no strictly legal from the point of view of the definitions, but one of the points I am making in general, based on the experience we had, is the fact that one of the big issues for the, I don't know whether the legal efficacy or for the effectiveness at level of the culture of justice and truth, which is what is said in the title, comes exactly from the fact that there is a profound, I insist, profound dissociation between the language of justice and the language of truth. In the sense that while people are clearly understanding truths when evidence is present, the recognition of truth by justice is a difficult issue. And every time is a big challenge, possibly the big challenge. I will make some cases in order to illustrate that. Again, I don't pretend to be doctrinally fully correct. I do reflect, however, an experience that we have gained over now, and Andrew was underlining that before, 35 years of work. We have been working for many cases, up to 40 of the many cases which are present in the general literature have been produced by the Permanent People's Tribunal. The Permanent People's Tribunal is not run by incompetent person like myself in juridical laws, but by jurists. Professor François Rigaud died last year, was president of the Permanent People's Tribunal from the beginning, and many of the things which have been developed were based, in fact, by his experience, his way of looking at international law, possibly because he was also specifically competent in international private law. And one of the big problems which are facing today is the fact of the relationship between the public and private points of view on law, which is, I think, the big challenge of People's Tribunal today. Let's see whether I could move ahead. Just to move next. Okay, perfect. This one? Yes. Okay. So I make a few historical remarks briefly in order to give the historical framework. Things have been quoted. I apologize for some repetition, but I think that it's good to have different point of view on the same issues in order to see the readings. First, everybody agrees, and we are born, all of us, from the crime of silence of Bertrand Russell and Jean-Paul Sartre for Vietnam. That was back in the 60s. It's interesting that possibly to remember that the crime of silence was so clear that the session of the Russell Tribunal could not be held in Paris, where it was planned, despite of the importance of a philosopher like Jean-Paul Sartre, because of a strictly political reason. De Gaulle forbidden, said states cannot be judged by anybody. It had the advantage of being very, very clear, to say you are nobody. And in fact, the fact of having a tribunal in Sweden, Denmark, outside the big geopolitical power, was a symbolic and concrete way of underlining that the crime of silence was in fact something which was the crime, possibly not specifically of those who were involved in the perpetration of the facts, but of the international community. It was interesting that obviously everybody knew about the bombing of Vietnam since years, and the fact that was the big issue immediately after also the killing of Kennedy. Everybody knew, but in fact nobody was talking of that as something which was a crime. The crime of silence was in fact much more, not to disturb the states, just the opposite, but the fact that that was part of the game. It was accepted by the international law that a war could go on with the silence of the international community. International lawyers were discussing, but at the end, the war could go on. And the fact of producing evidence which affirms something which was beside the official point of view was in fact a change of paradigm. Was the fact of saying, look, we have, as human beings, the right and therefore the duty of speak out and to present another point of view. It's interesting to see that the second Russell Tribunal was a Russell Tribunal on Latin America, is absolutely absent of the scene. Nobody quotes it. Nobody knows it. It was possibly much more important from the point of view of the implication for human rights. There was a war there, bombing, everything was clear. The dictatorships in Latin America, and here we have a Chilean testimony, or in any case somebody who comes from their time, certainly the Chile case, because of the ferocity of Pinochet and the visibility of some of the Chilean group was visible, but then after 73 and after so many things happened, in fact, everything was going on perfectly well between the international community in Latin America. Not only, it was shown as a very well-functioning laboratory of collaboration between a war on terrorism and the economic development. In 78, the World Championship was in Argentina, was won by Argentina, and everybody was very happy, with the exception possibly of the Netherlands team, because they lost, and however, they were the only one who didn't accept to receive the medal from the dictators. Otherwise, everything was going like before. Now, it's interesting because possibly Latin American people were outside the geopolitical criteria. They were belonging as a courtyard to the United States according to the Moore Doctrine. And where the results were presented of this tribunal, some of those results were presented also in the international community. Even some major journals were very open journals say, yes, there is a group of voluntary people who are presenting things, but yes, that's fine. The people were including both Hortensia Allende, Julio Cortázar, Garcia Marquez, well-known people. But they were people. They were not politicians, international jurors. I say that because the critical issue of the the Tribunal on Latin America was, as I say here, to look more closely to some of the causes of what was happening. And the causes were not simply the political bombings and like that because of power. There was the first inquiry on a power which was becoming more and more clear, and was that of multinationals which were involved directly in the coup d'etat of Chile and then in the policies of Latin American states, with the connection of European government. All of our government were involved and were in fact making contracts with those countries with some respect with for the exiles, but for the rest, maintaining all the relations because they were economic power. So the doctrinal implication was, for the first time, and the conference and the session on Brussels was clear, how you qualify the reciprocal responsibility in terms of international law. Are human rights enough to condemn what happens in economic fields? And if you are not referring to existing laws, what could you do? Victims are more or less important than perpetrators. Should victims justify themselves, or should the international community take charge of the victims, even if the tribunal cannot, because they say that there was internal issues. Argentina, at that time, was very, very similar, different completely from political culture, but the data presented before about Iran and the massacre are closely represented somehow with some of the acts of the dictatorship in Argentina with desaparecidos. Desaparecidos were not appearing for the first time, paradoxically, with the term in Argentina. They were desaparecidos before in Guatemala, Arbenz and all the people. They were thrown simply in volcans, but they were Indians. So the problem of the visibility of the victims and the qualification of the victims is clearly an important point. In that sense, I think that one of the issues which raised or caused the origin of the Permanent People's Tribunal and the name of the Permanent People's Tribunal was an intuition or an hypothesis, or possibly simply a matter of fact, that those who were part of the, mainly lawyers in that sense, part of the tribunal in Latin America, decided with Lelio Basso that it was in front of the absence of a paradigm capable of including not simply some of individual killings, but phenomena which had a collective implication and which were practically produced legally. The Brazilian dictatorship was recorded before. They are trying now to take back the documentation we have prepared in '76 to look for the memory, because at the end, the qualification of those who were the opponents were very similar to the terrorists today. And they were called for the doctrine of internal security. They were internal enemy. That was an internal matter, not a problem of international problem. Why are you entering what happens in my country? Which is the critical issue at the end of the Universal Declaration of Human Rights. And in that sense, what we need, which is not simply an affirmation, but really an hypothesis, a challenge, a research project, was to have a universal declaration of the right of people, which was in Algiers. At that time, those of you who are younger than I am, but at least old enough to remember that there was the groups of non-aligned peoples and different liberation movements. And that was really the idea that peoples, and that's the reason because why I think that is not, I think it's good for the public opinion to have opinions tribunal, but People's Tribunal is somehow different from Tribunal of the Public Opinion. People's Tribunal are, at least in principle, those who are really generated by what happens to a population, be it a full population, a group of population, all the issues which have to do with the definition of people, but in the sense that there are the people, again, I know I am very imprecise, but those are the people who are in the preamble of the Universal Declaration of Human Rights. That is the background, we people of the world. And that is something which is not simply possibly a preamble, that is also a target. We people are becoming people. States are in between. States are instruments. They are not, in fact, the goals, not the subjects of Universal Declaration of Human Rights. They must be the defender and the promoters. Peoples are, in fact, those who should be protagonists. And in that sense, the evidence should come through the more complex evidence produced by people than that simple evidence produced by legal experts, which by definition define evidence if the evidence corresponds to what we define as evidence. I say that as a doctor, every time that you see this morning in the Times that there is a recommended treatment for cancer, who define recommended treatment for cancer? And who define that for a woman who has the cancer and for the UK health system, which has decided that health is no more a human right? Is a real problem. And that is a general problem also in the world. We could go back for a major problem in that sense. And in that sense, the permanent People's Tribunal was permanent in the sense that the idea was not to pretend to be permanent, but in order to face a structural challenge, it was necessary to have something permanent, something that could be not simply the response to individual case, but the framework, the container, the laboratory where different concepts could be developed faced by the spectrum of problems which have been faced. From the first case, the independence or the existence, the visibility of the Saharan people was unknown, was a colonial, was quoting more or less like the Rohingya at that today. At that time, they were the inhabitants of the desert, no written memory, they have oral memory. They were living in the desert, which was belonging to the first occupant, Spain, Morocco, and they didn't have that. So the work of the tribunal there was just to rebuild with them the memory of what that was their memory of rights, and to constitute the first document. It was the basis for establishing a statute to be presented to the African Union in order to recognize that somebody was translating their cultural, historical right into terms which could be recognized by the international community. It was a kind of, say, of truth which was a translation from inexistence, invisibility, to something which should be recognized by the international community, but because it was at the end existing. So that was, but then the second one was for Eritrea, and then again back to Argentina, and then, so the questions posed to the tribunal were in fact documenting the wide variety of the problems which were presented, and in that sense, the idea of having a body of people ready to convene on a voluntary basis everywhere with the same methodology in order to create a consistent body of evidence. Our weakness, and I know, beside the fact that we were always very poor, so we don't have research, and Andrew could testimony that was, we were also using, and that is interesting again for international law, we were also using languages which are in fact so marginal. French, at that time Spanish, now is better, but not so much. Because Spaniard, in order to be recognized, must express their term in English. Otherwise, the translation is always difficult. Or we were just presenting those things for people who were in fact, battling for. The third point for the framework was one of the texts which I think has been most interesting for the Permanent People's Tribunal, was really one of the production, historical juridical production of mainly François Rigaud, and other jurists from different places, with the important contribution of some also poets, authors of Latin America, from Susan Castor to Eduardo Galeano to others, who were there really to translate into visibility something which was clear historically but was not different. You remember in '92 there was this 5th century of the so-called discovery of the Americas. All of us know now that that was not a discovery, it was a conquest of America, but that was really more importantly for the international law was in fact, the date of birth of international, not directly 92, but at the end, the international law is born in Europe to justify the conquest of America in terms of discovery and civilization. International law is born from juridical people here in Europe, mainly in Spain, the Victorian and others. I am repeating what those juries were really documenting clearly. And that was the basic, possibly, scene of international law. International law is born conceptually to justify or to qualify what has been happening, not to foresee what will be happening. Is not born to foresee and promote rights, is just to justify violation of rights. And in fact, just to frame, that was a kind of matter of fact, states that the history is not simplified, obviously, but it's interesting there just to to raise the question, what is the permanent challenge of international law? To be a backwards-looking law, which is looking for what has been violated, and in that sense, the violation of the Indians of America was the fact, and is a very modern scene, was the fact of not accepting the law of commerce. They were not accepting, in fact, that together with the gospel, they were announcing free trade. Free trade at that time, like today, is just to take out the goods they had because they had to be transferred into a world where trade was, in fact, the big problem, which was not their problem. They had many problems for cruelty, for whatever, all people. But if you see the development of that is, in fact, an international law which is born out of a theological power, which was then very important for all the philosophers of the time in Europe. So just to give the idea of credibility, civilization, but then the civilization was linked to baptism, to belonging to an ideology, and then to the fact that those who were not accepting to make a change, to accept rules, had to be declared enemy or heresy. At the end, non-humans, you are possibly aware of so many publications and of the fact that the Indians were recognized to have a spirit, to be human, later on. They were simply considered to be non-human because they didn't have a God, they had some beliefs, they were not dressed very well, not dressed at all. They were different. It's important that because if you see what are now, take for instance the recent the recent meeting of the FAO in, sorry, I didn't see that, the FAO in Rome, they were discussing the post-2015 millennium goal. And they said they discovered that certainly the right to food should be considered about the goals. which is a very astonishing discovery. To discover that the right to food should be at the end considered a right. Not simply, but that is critically important, not simply a chapter of commerce, because that was part of the trade, is declared a right, like health is declared a human right since the very beginning. Now, if you simply see how much the Ebola affair is dealt with in the world in terms of investment, it's just a good model to see that, in fact, a right becomes a right if you have a person who is sick in the States, not if tens of thousands are sick in Africa. Certainly they are Indians. But I say that because these things are those which are then translated into the fate of prisoner, whatever. And that is very critically important. So now, in order to, because then many others will talk about different things, what I see in this sense could be the aims of the challenge of the People's Tribunal, and I certainly repeat something which is somehow common sense. I think it's interesting to imagine that this common sense should be seen as a permanent challenge of all tribunals which are convened from whatever side, in order to produce progressively a doctrinal body of knowledge, of terminology, of pressure, so that all tribunals, despite the differences were mentioned before, water, food, health, individual freedoms, which were the most traditional for political things, all of that could be the same. Recently, I will come back to that, it was mentioned, the Russell Tribunal on Palestine. At the end, it was the best demonstration. I was part of that from the very beginning. That was the tribunal who declared the powerlessness of the international law. In fact, everybody knows what goes on in Palestine. Everything has been judged. But then it is clear that it is important to repeat and to repeat and to repeat, because the matter of obligation, which is linked to the international law, is something which is in itself a matter of demonstration. The best evidence is that there is no mandatory link between legal things and the application of that. And that is something which is critically important for the vacuum of international law. And the vacuum is made up of various steps. First, to provide a tribunal visibility, the tribunal not principally as a matter of condemning something. Again, Palestine, we will discuss later on with those who are part of that. Palestine and Israel. If you have followed something already also here in UK about the publication on the Palestinians who were bombed and killed, and there was a group of international doctors, including Sir in Chalmers, many friends and colleagues of mine, and there was a rebellion simply because there was a letter in a medical journal declaring that there was an excessive killing with respect to defense aid. So nobody could deny that. But there was a kind of pressure just to say to the journal. They were obliged to send the problem to the ombudsman to evaluate whether to declare an excessive killing was not an attack, an anti-Semite attack with conflict of interest with respect to that. So the evidence, which was in all the televisions, whatever. So I think that we are really the visibility and the identity of people who are not represented. The Rohingya, we are involved somehow with them after the Tamil. Rohingya is a case which is becoming more evident, possibly, in a country which is with a Nobel Prize for peace. So it's something which certainly something is growing. I think that it's important to provide a qualified visibility at international level, then to promote the development of innovative interpretation and formulation of juridical principles is an important problem. And then I will close on that in a few minutes. Then the fact that we have, and the victims, the second and the fourth one of the big issues for people's rights and for tribunal is that victims are very much re-victimized, has been said, because they are forced to document that they are victims. I remember the tribunal on Bhopal. The main point which was discussed with the judges and the experts of the tribunal there, from Indian government and obviously the Dow Chemical, was, and again is interesting, the crossing of medical aspects. How could you document that those who have died have been killed directly by the gas? They could possibly have been already sick, so the gas was not a cause, was a concause. So the payment for insurance, you know that the victims have not been paid except with the insurance which was got from the Dow Chemical. Now, the problem was you should document, and that was requested. I remember the meeting with the people from the tribunal. They should present the medical records before the accident. Imagine in India, in that situation, they were not even knowing what was medical record or whatever. But that's part of the, that was the same for multinational now in India, from the multinational, both Glaxo from UK here or from Novartis, when they have to give money, to give drugs in the sense. So victims must justify themselves, and they can justify only if they have money to justify, instead of being recognized as victim. Recognized as victim is not only, all of us are very much in favor of the memory, possibly if the memory is not so far away. The Brazil opening, one of the BRICS, who is opening now the process of memory of those who were killed by the dictatorship or imprisoned, say much about the timing of the international law. And that is something which is very important for the victims, for the family, for everybody, for the credibility of international law. If the international law is simply a cultural aspect of a fact of memory, obviously it's different. And then I think that People's Tribunal are by definition something which must be a tool for alphabetizing peoples around the world in order to be involved, to recognize themselves throughout the tribunal. Iran, Iraq, everybody. And in order to conclude, I apologize, but I lost a few minutes for technical problem before, so you justify me, but just to conclude and to say that we are, just to show some cases where I think I'm not expanding on that, some of the issues which were discussed during the tribunal in many instances. What is a genocide, or what is a genocidal process? Is important or not qualify something as genocide? Not because they say, legally I understand. There is not a matter of difference between crimes against humanity in terms of if you must give a pain to end genocide. But the fact that genocide was and is a symbolical, mythical term, what is important is not the same. The desaparecidos of Argentina were a product of a multiplication of killings or disappearance, or was a purposely genocidal process. The tribunal decided on that sense, and now the tribunal are trying to do that. But the same could be done for East Timor, Guatemala, the Brazilian Amazonia, everybody discussed about deforestation. The human side of that disappears. The Armenians, as was quoted before by Andrew, the ex-Yugoslavia, the Elam Tamil, which is an ongoing process, as we have said in a verdict was presented in the interacting with the United. Then main point, economic impunity. Everything which is committed out of economic reasons is by definition not of the competence of the criminal court. The criminal court declared before its institution in Rome, with an exception, that economic crimes do not belong to their competence. Now, it's very interesting to see whether somebody could find something which happens today without economic causes as a main route. But if you say that, and I say that because, for instance, starting from our verdicts on the World Bank and the IMF, the International Monetary Fund, throughout, and now the Monetary Fund declares, and I quote Greece because it was documented again in an international British journal, Lancet, they recognized that they were wrong, and profoundly and conscientiously wrong, in condemning Greece to a policy of austerity and destruction of the system. They recognized. They don't even need a tribunal. They could simply say, okay, they have said, the president, everybody. Now, if you read the paper of the Lancet, beside other things, which is a medical journal, to say what happens to newborn, to the increased mortality of infants, mother, unemployed, everything. A culture destroyed. Who is responsible for that? Nobody. It's an economic principle. It's a matter of difficulty in planning or possibility of interest. But if you expand on that, then you could easily discover that these economic principles could go everywhere. Somebody has said that so many deaths could be avoided by war. That's clear. If you say the hierarchy which is existing now between the treaties on goods versus right of people, and you see the treaties on food, water, drugs, all things which have a relationship which is very strict. Most of the places where people who need that are living, like drugs and life. Do you know that in no country all the drugs which have been discovered are life-saving and mandatory? In our rich country, none of those drugs is available in any of the developing countries. So we are counting every year the avoidable death. It's not a problem simply of accessibility, it's a problem of price fixing. But how to price fix? And then if you take other, and that is really close, other problem like the migrants, we are now in a process of having a long session with a wonderful participation of tens of thousands of people in Mexico, looking for what happens in Mexico. Mexico has been rediscovered in these days because 43 students have been massacred for nothing. They disappeared. They are in common graves. But that is just a last emergence, which was really dramatic because the students were part of something which is common. But that's, if you see in Mexico, a recent report was sent back by the authorities in Mexico International because it was counting only 9,000 deaths. They had to be more complete in the documentation of the case. So I think that we are, and the same is true for the Mediterranean. Europe, Italy is dramatic, but Europe has worsened the condition now because we had at least a law for that. They promised to have a law, but then with a law without money to invest to implement. So we have chapters which are really unmet, and I think one of the big roles of the tribunals are permanent roles of all the tribunals in complementarity, in connection, should be really to get specifically this challenge of reconceptualizing, making more effective, more near to people, in order that at the end, as it happens when some paradigm is changed, under the pressure of the disaster of the World War II, the pressure of the people or the victims, obliged to make a jump in the conceptualization of human rights. For the first time in history, everybody says that human rights are young, they have a future, hopefully so. People's rights are also young. In a globalization situation, the term itself of people is disappearing as a reference term, and I think that international law could not simply apply itself to economic treaties, transatlantic, trans-Pacific, trans-whatever, because all of those treaties are in fact a drawback and a step backwards for human rights.